After the case is over, sealing records, expungement, and moving on. The case is over, the charges were dropped, or you were found not guilty, or you completed your sentence and you have paid your debt. Either way, the legal process has concluded and you want to move on with your life. But there is a problem. Your arrest record has not moved on with you. In Texas, an arrest is a public record. Even if the charges were dismissed, even if you were acquitted at trial, even if the case was thrown out for lack of evidence, the record of your arrest remains in public databases unless you take specific legal action to remove it. This means that every time a potential employer runs a background check, every time a landlord screens a rental application, every time a licensing board reviews your credentials, that arrest is visible. And in a world where background checks are standard for employment, housing, and professional licensing, a visible arrest record can quietly close doors you never even know about. The good news is that Texas law provides two paths to address this: expungement and nondisclosure. They are different tools that accomplish different things, and understanding which one applies to your situation is the first step toward reclaiming your record. Let's start with expungement, which Texas law formally calls expunction. An expunction is a complete erasure. When a court grants an expunction, the arrest record is destroyed. Law enforcement agencies, courts, and background check companies are legally required to delete the record. Private databases that purchase the information before the expunction are required to remove it as well, though enforcement of this requirement varies. After an expunction, you can legally deny that the arrest ever occurred. On job applications, rental applications, and any other context where you are asked about your criminal history, you can truthfully say that you have not been arrested for that offense. The record no longer exists. Expunction is available in several circumstances. If your case was dismissed, you may be eligible. If you were acquitted at trial, you are eligible. If you were arrested but never formally charged and the statute of limitations has passed, you are eligible. If you completed a pretrial diversion program, you may be eligible. If you received a pardon, you are eligible. There are waiting periods for some of these categories. For a Class C misdemeanor, the waiting period is 180 days from the date of arrest. For a Class A or B misdemeanor, 1 year. For a felony, 3 years. These waiting periods apply when the case was dismissed and no charges were filed. Now let's talk about non-disclosure. A non-disclosure order does not destroy the record. Instead, it seals the record from public access. This means that private employers, landlords, background check companies, and most of the general public cannot see it. However, law enforcement agencies, government entities, and certain professional licensing boards, including those for healthcare, education, and law enforcement, can still access the sealed record. Non-disclosure is available for defendants who successfully completed deferred adjudication. Deferred adjudication is a type of plea arrangement where the judge does not enter a finding of guilt if the defendant completes all conditions, such as community service, classes, or probation. Once those conditions are completed, the case is dismissed. Not all offenses qualify for non-disclosure. Family violence offenses are permanently excluded. Sexual offenses, murder, aggravated kidnapping, human trafficking, and certain other serious crimes are also excluded regardless of how the case was resolved. For eligible misdemeanors, non-disclosure may be available immediately upon completion of deferred adjudication. For eligible felonies, a 5-year waiting period applies. The process for obtaining either an expunction or a non-disclosure order involves filing a petition with the court. For expunction, the petition goes to the district court in the county where the arrest occurred. For non-disclosure, the petition goes to the court that handled the original case. Filing fees vary by county, but typically range from $280 to $350. Many people hire an attorney to handle the petition, which adds additional cost but helps ensure the paperwork is filed correctly and increases the likelihood of approval. The timeline from filing to receiving the court order typically runs 1 to 3 months, depending on the court's docket and whether any objections are filed. Here is the key takeaway. The Texas legal system offers real paths to clearing your record, but those paths require you to take action. The record does not seal itself. The arrest does not disappear on its own. You must file, you must follow the process, and you must meet the eligibility requirements. If you or someone you know has a past arrest that is affecting employment, housing, or professional licensing, consult with an attorney who handles expunctions and non-disclosure orders. Many offer free initial consultations and can tell you within one meeting whether you qualify and what the process will look like. Your past does not have to define your future, but only if you take the steps to address it. Freedom Bail Bonds. We are here for every stage of the process, from the moment of arrest to the moment you move on. 915-265-5650